This may sound familiar, and if it doesn't, I hope you don't have to experience this. After losing a loved one, you're barely ready to handle all the legal ramifications of what's to come. You find out that all their accounts are frozen. You don't know how you're going to pay their last expenses. You don't know what assets they've had. You're uncovering their household items, trying to figure out if they did leave a will or a trust in place. Meanwhile, every bank and institution that you're trying to contact to retrieve some information about your loved one's passing will not release information to you. They tell you you either need a letter of testamentary or an order from the court. In short, that means you have to go through what's called probate. In this video, I will cover three main things: what is probate, what it entails, and ways to avoid it. Probate, or probate court, is the way that assets transfer after somebody has passed away. Title to an asset has to transfer, and the government wants a way to make sure that title transfers to the intended people. So the government provides what's called probate or probate court to make sure that the proper person is appointed to manage those assets and is able to transfer them to the intended beneficiary. We talked about probate existing in order to transfer title, but what is the process that's actually taken to transfer that title? The probate process requires usually an average in California of 2 years to be able to petition the court and say, I want to be the administrator or executor of the estate of a loved one that passed away. And I want to be able to manage those assets and then get court approval via court order from the judge to be able to transfer those assets to the intended beneficiary. That process is expensive, it's time-consuming, and it's a public process. So many families, including many of my clients who have gone through this already, never want to go through it again and want to tell the world how to avoid probate, because it truly adds such a complex emotional level to the already complex legal considerations of losing a loved one. Now I'm going to discuss ways to avoid probate. These are simple steps you can take whether you have a large estate or a small estate. Make sure to update beneficiary designations and secondary beneficiary designations, sometimes called contingent beneficiaries, just in case that the beneficiary you had on one of your accounts is not around to receive that asset. We have a plan B for who may be able to receive it. The other part of updating beneficiaries to your assets is to make sure you have a durable power of attorney. That way, if you lose capacity to make decisions over your assets, that durable power of attorney, if we give them the ability to update beneficiaries in an attorney drafted document, then they can come in after the fact and update your beneficiaries. That way we have no asset without a beneficiary, and we can avoid probate on that particular asset. Remember, the reason why we're able to avoid probate is because the asset has a home base. It doesn't have to go through the probate court process to be transferred. One way to do this is to own assets jointly. When you own something jointly, the survivor of the two will be the 100% owner of that asset. This usually is able to happen with most bank accounts and even real estate if you own with joint tenancy with right of survivorship. This may not be the best plan for every asset or for every family, but it is a plan to avoid probate, at least when the first owner passes away, but not a plan to avoid probate when the surviving owner passes away. The survivor definitely needs to do additional planning to make sure they avoid probate too. My favorite way to avoid probate is using a revocable living trust. It's sort of the catch-all plan for all kinds of assets, whether you have a large estate or a small estate, especially if you have real estate, because we transfer all the assets inside of the trust, meaning now that the trust will own your assets. So if you pass, you don't have any assets, your trust owns them all. There would be nothing subject to probate. And the best part is the revocable living trust, you create, you design, and you put the rules about how everything gets divided, sold, transferred, etc. It's the best way to give you the most control over your assets with no court supervision. Just remember to go back and look at the accounts you have, make a quick audit of your financial situation. I think you'll be surprised to find that some of your accounts may be missing a beneficiary. Life is crazy. We forget to do things sometimes. So go back with something as simple as updating beneficiaries. You could avoid probate, and your family or loved ones won't have to go through probate. Just remember, it's very simple. Just do an audit of your current financial situation and what assets you do have. Make sure the ones that you do own have a beneficiary on them. And in more complex situations, the best way to avoid probate is to get a revocable living trust, which gives you the most amount of control and smooth transition of your assets without going through probate. I'm here to help. You're not alone in thinking through this. You can always email me at noelle@barthattorneys.com. Why choose probate if you don't have to? Thanks for watching.